So, very good evening, friends. Today we'll be starting with part 3, insolvency and bankruptcy of individuals and partnership firms, which starts with fresh start and then goes on to insolvency and then bankruptcy. For this, Prakash Kukreja ji is with us, who is a chartered accountant and an insolvency professional. So he'll be guiding us, and he has been with us on earlier occasions as well. And he has been guiding us not only on the law provisions but the practical implications as well. So please, sir, it is all yours now.
Thank you so much, Gupta sir. Thank you. And a very good evening to all of you. So, with permission of Gupta sir, before we start with personal insolvency, I will just share with you how the NCLT order is shared. This will give you some idea. So first, let me share with you how the code from the order comes, like how do you get notified. So I'm sharing my screen. Let me know in case if you don't see it.
Yes, sir. Yeah.
Visible, right?
Section 78.
Yeah. So, sir, first I'll show this one. So this is an example of how every day, like every day, there is a court proceeding. So, for example, this is NCLT, Mumbai bench. There are 5 courts in Mumbai. So this is court 3. And then they talk about who's a judicial member and technical member. I'm sure you will, when you will read the NCLT rules, you'll come to know what exactly they are. Then they talk about the date and timing when it will start. Then there is a video conference ID also. So you can just click. In fact, anybody can join. It's a very interesting session. So I usually try to attend 2 or 3 sessions a month, a week. And it's very interesting what exactly the kind of questions they ask. So it's a good practical view which you will get. And you would see IRP, RP litigator should be present in person during the hearing. So it is always expected that if there is, this is obviously most of the cases are for IBC only. So any cases wherever they are expected to be in person. Now, I'll just give you an example. This is under section 7 of IBC for pronouncement of order, which means this was already discussed earlier. Now, basically, the bench wants to take a decision whether they will pass the order under section 7 or not. Then they talk about who is the counsel, basically the advocate. In some cases, it could be the RP also. And then who is the parties, right, who has already pronounced. So I'm working with a very senior associate in Mumbai, and this is the case which was on 6th of September, they actually passed the order for section 7. So this was the one. And if you go further, now if you see this is admission. Further consideration, basically if there is any specific date details which the bench requires, so they put it as further consideration. And if you just go further, there are approximately 30 cases for this bench. Usually what happens is in the first 5 to 10 only, the entire time for 2 to 3 hours goes. And then what they do is they basically give a separate date for other cases. In some cases, they will say there is a physical hearing. So for this case, if you see number 14, there is a physical hearing. So this is how you get to know about these proceedings. Now I'll just show you that once you get appointed, how exactly the email comes from NCLT. So when I was appointed as an IRP, right? So this is an email which I got. It says I am directed to inform that Honorable NCLT has appointed you to act as a IRP for the panel of the names. So I was already impaneled with IBBI from this one, July to December. And for that case, the proposed RP's authorization for assignment was not valid. So my name was the first in the impaneled list. So that is why I got appointed for the Bank of Baroda case. This is again a PG case. I'll cover more in details when we look at section 95. And they also mentioned that the order in the aforesaid petition has been pronounced on 11th of August, right? And therefore you're requested to file your declaration and disclosure statement within 2 days as per the provisions of IBBI. So this we have to do it on the IBBI website. So once you become an IP, you will have a dedicated login password. And then we'll, once Gupta sir bases his plan, I'll share the IBBI website also, how exactly we log into IP, how we fill up different forms. I'll show you all those
But
forms also.
Kureda sir, there is a question.
Sir.
The email is dated 6th of August.
Yeah.
And they say order has been pronounced on 11th of August. How come?
Sir, actually, this order was pronounced on 5th of July. I got the email on 6th of August.
Okay, but why they are saying the order in the aforesaid place is pronounced on 11th of August?
No, basically what they're trying to say is on 11th of August, there was a hearing, which I attended. So this, I don't know, sir, there might be some typo, but
Okay.
actually the 11th August was the hearing.
Because for 11th August, how can they write email on
Exactly.
the 6th of August?
Exactly. Yeah. So there is a typo, sir.
Okay,
so actually the order was on 5th of July.
Okay, sir.
Okay.
So had IP committed this mistake, they would have issued this show cause notice.
Absolutely right, sir. Absolutely right. And one very important thing, which was again highlighted in the recent amendment. So this case, which I got it. So if you see here, I have created a separate ID for this. No, this was in. So I have created a separate ID for this case. So now in the exam, there might be a question that IRP, RP should always create a separate email ID, whatever case they are handling. And if suppose I am the IRP, and then once, let's say, I don't continue to be the RP, so I have to hand over the email ID and password to the RP. So now this is an important change and a law requirement. So with that, let's move to the presentation for today. So this is just like setting the context for today's session. So today we will be looking at individual insolvency and individual and partnership insolvency. So I think previously we have covered for SMEs, then liquidation, CRP. Now this is related to individual insolvency. And this is covered in the part 3 of the code. Okay. So before we get into more details, what I thought is let's look at the overall coverage, right? So I'm sure by now all of you know that we have a separate code, then there are regulations, and then there are rules also. So in this case, as far as individual and partnership is concerned, within the code, it is further divided into 5 different parts. So the first part, which is section 78 to 79, that is called preliminary, which basically talks about all the definitions. So if you remember section 5 for CRP, that gives you the idea about all the definitions, same over here. So we'll go through this also. Then there is a fresh start process. This is very unique to individual insolvency. For a specific category of people, especially individuals, this is applicable. Then we have insolvency resolution process, right? From section 94 to 120. And then we have the bankruptcy, section 128 to 150, 148. And then 150 to 178, it is the bankruptcy estate, how to manage a bankruptcy estate. Because see, one important thing which I'll highlight here is that when we are looking at a CRP and liquidation, so in case of individual and partnership, it's exactly the same thing. It is insolvency and bankruptcy. So bankruptcy is equivalent to liquidation. And as I was talking about this, the last part, which is section 150 to 178, this is when they create a bankrupt state, how that is being managed. So what are the exact duties, roles, and responsibilities of a insolvency profession? That is what they have highlighted. And that is why they have dedicated one section for that. Then we have regulations. So these regulations are dated 2019. And as of now, it's only for personal guarantor, as far as individuals is concerned, that has been notified. But for partnership and others, it has been not yet. So it's only personal guarantors to the corporate debtor. So these regulations are as of 2019, and there are 2 of them. One is for the resolution process, and second is for the bankruptcy. And then we have rules. So this is basically the procedural part. How do you apply to the educating authority? What are the fees? What are the forms, and so on? So we have to cover all this when we are looking at individuals and partnership. So any questions so far? Okay. So let's discuss some of the important terms which are related to this. So is IRP or a bankruptcy being notified for individual partnership? So this in a way I've covered it. As of now, CRP liquidation, voluntary liquidation, this already been notified, but for individuals and partnership, it has been not. The only exception is the personal guarantor, right? And this personal guarantor, the definition has been made it very clear that a personal guarantor to a corporate debtor. So when we are going to go through section 90 onwards, specifically 95, 96, 97, 98, 99, there we will discuss about the personal guarantor. So as of now, it is only for PG, rest all are not covered. Then another question which comes is that who is the educating authority for individual or partnership? So as far as CRP is concerned, liquidation is concerned, I think it's very clear that this is the NCLT, correct? But in case of individual partnership, it is DRT, right? That is Debt Recovery Tribunal. Then assets of CDs in CRP liquidations are key. How about in this case? See, whenever we have a CRP or liquidation, let's say, for example, liquidation, what you will do is the liquidator will actually auction these assets, correct? And then whatever money they get, that is what will get distributed to the as per section 53. But what happens in case of individuals? So they have made it very specific that the assets, so they have defined excluded assets first, right? So these are assets which will not be included, because normally in case of a CRP, let's say if it is a manufacturing company, they would have a land, plant, machinery. So as a RP or as a liquidator, you will have an option to either, in case of a liquidator, you can auction those assets and realize the money. In case of RP, you have an option to run that factory, right? If it is a going concern, or look for a resolution applicant who can come and take over the factory. But in case of individual partnership, to define the assets, what they have done is, first they have defined which assets will not be included. So these are called excluded assets. And in the exam, you can expect 1 mark MCQ on this. So what are excluded assets? So first is, it should be, the basic, it should be unencumbered. Basically, there should not be any charge on the assets, right? So what are those? Tools, books, vehicles, and other equipment which are necessary for the personal use or employment, business, or vocation. So they have not given any specific amount, but they have just given what are the broad definition of these unencumbered assets which will be excluded. Next is furniture, household equipment, which is necessary for satisfying basic domestic needs of the bankrupt and his immediate family. So immediate family also has been defined when you look at the code, but this is also excluded. Then personal ornaments of such value. So in the rules, they have given the value, which is maximum rupees 1 lakh, right? So personal ornaments of the debtor or his immediate family, which cannot be parted with in accordance with religious usage. A very simple example could be like in case of we Hindus, it's Mangal Sutra, right? So the maximum amount which they have restricted is 1 lakh rupees. So these are personal ornaments, and they are part of the religious usage. Or maybe if you have an idol of a god, like a temple at your house, and that maximum 1 lakh rupees, that will be excluded. Life insurance policy or pension plan taken in the name of the debtor or his immediate family. Okay. So again, LIC policy, again, very important. All these assets should be unencumbered. That is a very important one. And also note that if there is a life insurance policy for an immediate family, that also will be excluded. Single dwelling. Now this dwelling basically means a house, right? So single dwelling unit.
Hello.
Haan, sir.
Sir, even this 1 lakh is market
Gupta sir, you're
value.
trying to say something?
What I'm saying is, even this 1 lakh is market value only.
Correct. सर शायद कुछ नेटवर्क में प्रॉब्लम है, आपकी आवाज नहीं आ रही है।
Okay, okay.
आई
No
डोंट
issues.
नो अदर्स आर एबल टू हियर।
Okay.
यस सर, अभी आ रही है।
आ रही
सर
है
अभी आ
ना?
रही है।
तो ऐसा
हाँ,
सर, even this 1 lakh is market value that I wanted to point out.
करेक्ट करेक्ट, यार वैलिड पॉइंट। यस। So, moving on, single dwelling unit owned by the debtor of such value as may be prescribed. And in the rules, they have prescribed that for urban area, it is 20 lakhs, and for rural area, it is 10 lakhs. This rural area is also defined, if I'm not wrong, that we will see in the code. But as per, if I'm not, I think Employment Act, they have defined what is a rural area. And urban is whatever is not rural, that will be urban. So in my exam, what I recollect is that I had a case study which was on this personal insolvency. In that case, what they had given is that there was a house which was owned by the family member, right? Now, in this case, it says owned by the debtor. One. Second, there was one more option which was given, that house owned by the debtor, which is actually already has a mortgage. So which means there is a charge, right? So it is not unencumbered, it was income. So these kind of questions you will get in terms of this insolvency, individual insolvency. Now, what is a default amount? So in case of CRP, we all know that it is 1 lakh. In case of PPRP, it is 10 lakhs, right? In case of individual insolvency, it is 1,000 rupees, right? As of now, the amount is very low, but I was recently reading a committee. There is a report on IBBI website. You can just read it. It was a working committee which proposed that this amount should be increased from 1,000 to 10,000 rupees. But they haven't notified yet anything on that. But the proposal is that it should go to 10,000. If the amount is less than 10,000, then what they have proposed is that it should go under mediation. Because if the amount is so low, 1,000, then imagine the kind of resources being used specifically for the courts, judges, and IRPs also. So is there a resolution plan in line with CRP? Now, in case of individual insolvency, we know that the RP he actually publishes the Form G, and he requests resolution applicants to show the expression of interest and then provide the resolution plans. So in case of individual, there is something very similar, and that is called a repayment plan. Now, repayment plan basically means that here, the individual person, along with the discussion with the IP, he prepares a plan where he says, this is how I'm going to pay my debt, right? And that also goes through a process, which you will see when we look at the code. So there is a proper approval in place, which is required by the committee of creditors, and then it goes to educating authority also. But there is a plan, and which is called a repayment plan. Then will partnership include unregistered firms as well? So the answer is yes. So it would be both unregistered or registered partnerships. Now, there is one very important term as debt. So, for example, in case of CRP under Section 5, the financial debt has been defined, right? So there is something similar which we have to see how it caters for individuals and partnership. So how do we define debt in case of individuals and partnership? So what they have done is it's a two-way process. So there are two different things which they have considered. One is what is excluded and second is qualifying. So we look at each one of them. So this is following liabilities will be excluded to arrive at the debt. See, today if you take a loan, right, and tomorrow you say that you're not able to pay it, so you want to be discharged as a bankrupt, right, or you're insolvent. But that doesn't mean that there should be any misuse of the law. So that is where there are specific liabilities which have been excluded. Now, those liabilities are, one is fine imposed by a court or a tribunal. If obviously the fine would be imposed because maybe you have broken the law. So in that case, if there is any fine, it will not be excluded as part of it. So which means even if you're insolvent or a bankrupt, you still have to pay that fine, which was imposed by court or tribunal. Then pay damages for negligence, nuisance, or breach of statutory, contractual, or other legal obligation. So if there is any such instance, and maybe if there is a way to prove it, you cannot escape this liability also. But important that there has to be a breach of statutory, contractual, or other legal obligation. Pay maintenance to any person under any law for the time being enforced. The best example would be that in case if husband and wife have got divorced and husband has to pay an alimony, right, as per the law, which means he cannot escape that declaring himself as an insolvent or a bankrupt. So that alimony would continue. Student loan, correct? I think it's very straightforward. And any other debt that may be prescribed. So these are the liabilities which will not be excluded, which means the individual person has to pay these liabilities despite being declared as a bankrupt or insolvent. Now, the other angle to this is that if this is excluded, then what is included? And that is called as qualifying debt. So this is a very important definition. And I'm pretty sure that in the exam, if there is a case study, they will have at least 2 or 3 or 4 marks of this only on this slide itself. So what are qualifying debts, right? This is the amount due, which means the amount due by the individual or the partnership firm, which also includes the interest or any other sum due in respect of the amount owed under any contract by the debtor. So very simple example would be, say, if you have a home loan, right? Or you have a personal loan, a simple example. In that case, whatever interest you have to pay, because there's a contract, so that would be part of your qualifying debt. Then, and excluded, it says, but does not include excluded debt. And excluded is what exactly we saw above, right? The following liabilities which will be excluded. So it should not include the above. Then debt to the extent it is secured. So it says to the extent it is secured. So if you have taken a home loan, and let's say if the value of your house is, for example, 50 lakhs, whereas your loan is 1 crore, or let's say 70 lakhs. So up till 50 lakhs, it can be excluded, but the balance 20 lakhs will be part of the qualifying debt. And the last one would be debt incurred 3 months before the date of application for fresh start process. So we'll cover this fresh start process in the next slide. But basically, it says that any debt which was incurred 3 months before you applied for a fresh start process. Now let's look at the fresh start process. I hope there are no questions so far, so it's okay. Any questions? Okay. So in case of individual insolvency, if you remember, if I go back to the previous slide, there are different types of this thing which they have highlighted. So if you see, section 70 to 79 was definition, but section 80 to 93 fresh start process. So now we're looking at this specific section. Secure debt against PI. Personal, sorry, what is PI over here? Prakashji, what is PI? Personal insolvency. Oh, please. Okay. Okay. Secure debt, like the example which I gave you, let's say if you have a home loan, right? And let's say the home loan is for 70 lakhs, which means you owe the bank 70 lakh rupees, right? But the price of your house, the market value of the house is 50 lakhs, which means what will happen is the balance 20 lakhs is unsecured. So up till 50 lakhs, that part will not be included in your qualifying debt. So that will be removed. But the balance 20 lakhs will still be included as a qualifying debt, which means when you are filing for insolvency or bankruptcy, they will waive up to 20 lakhs, but not 70 lakhs. Is it clear, Prakashji? Okay. 1 lakh jewelry amount for the whole family, yes. So let's look at the fresh start process. Now, let's look at the eligibility, like who is eligible. This is a very interesting part, but of course, a lot of debatable given the amount which they have put it. So the first thing, if anybody wants to apply for a fresh start process, now first thing is that who will apply? It is always applied by the debtor, right? For example, in case of CRP, we know under Section 7, a financial creditor can go for a CRP act against a corporate debtor. Section 9, operational creditor. Section 10, the CD himself. But in this case, for a fresh start process, it is always the debtor who applies for insolvency. But before applying, there has to be an eligibility criteria. So the first eligibility criteria is that the gross income, the annual gross income, should be less than 60,000 rupees. Okay, number one, which is less than 5,000 per month. Second, the aggregate asset value should be less than or equal to, or maybe not more than 20,000 rupees. So whatever assets the debtor owns, the market value of that should not be more than 20,000. Third, aggregate value of qualifying debt. Now we saw what is the definition of qualifying debt. So that should not be, that should be less than or equal to 35 or should not be more than 35,000 rupees. And not undischarged bankrupt, does not own dwelling unit, whether it is encumbered or not, right? And there should not be any fresh start process or insolvency or bankruptcy currently ongoing for this particular debtor, or there was no fresh start process which completed 12 years preceding the application for this. So if all these 7 conditions are satisfied, then the debtor can apply for fresh start process. Now let's look at the process. So I'll start from the first box. This is like a process flow. The debtor with or without RP, resolution professional, will apply, right? So as I mentioned, this is done by the debtor. Okay. And then once he applies, he will be applying only for the qualifying debts. Now, in this case, qualifying debt should not be more than 35,000. So that is an important check. Now, in a case of individual insolvency, what happens is, I'm sure you all know that what is moratorium. Like I think Section 14, right, for CRP. So the moment application is admitted till the time resolution plan is approved or the CRP is completed, there is a moratorium period for CD. Now, in case of individual, there are 2 different moratorium periods. So first is called interim moratorium and second is called moratorium. Now, why? Because there are 2 stages. One is when you apply, right? When you apply for insolvency. So in this case, the debtor has applied for fresh start process. So the moment he files an application, the interim moratorium starts. And this interim moratorium will continue till the time his application is admitted. So there are specific conditions what happens during interim moratorium, which we will cover. Basically, again, any legal case, there will be a stay. No creditor can go against the debtor or file a legal case or a proceeding. So those all things will be stayed. So there are 2 moratoriums. So one is interim and second is moratorium. Now, after the interim moratorium, of course, depending on the process is that the application either will be admitted or rejected. So the next stage would be within 7 days, they have to apply for RP, basically a resolution professional. My bad, this is application, it's an appointment. So a resolution professional should be appointed within the 7 days after the application is filed. Now, within 7 days, of course, there will be a process where it will go to the board if there is any specific disciplinary case and so on. Let's assume that the RP has been appointed. So after RP has been appointed, his role would be to examine the application, right? And submit the report to adjudicating authority, whether this application should be accepted or rejected. And this is within 10 days. So if I quote my example, when I was appointed as IRP for the personal guarantor, now, though on the mail which I showed you, the mail I got it on 6th of August, but the actually order was pronounced on 5th of July. But I learned about the order on 1st of August, which means effectively the date applicable to me would be 1st August. So within 10 days, 10th of August, I was supposed to give a report to the adjudicating authority whether the case should be admitted or rejected. Now, there are specific things which RP needs to do. We will cover when we look at the code, but this is a very important role. Now, I'll just give you one personal perspective that whenever you're doing this activity, when you are actually uh, giving the report to the adjudicating authority, usually you don't get paid for this. But in some cases, depending on the expenses might get covered, but usually you don't get paid for this. And what happens is that once the case is admitted by adjudicating authority, then you start getting paid. That could be depending on your negotiation skills. But again, usually as a market practice, I have seen that RP doesn't get paid for this particular responsibility or activity. Then the next stage would be that adjudicating authority will either admit or reject. Who will bear the FSP cost? So Vinay Kanji, I think in this case, the cost would be that once you get to know that you have been appointed as a RP, you have to prepare a report and all that. So ultimately, it should be the applicant. But in my case, what happened is I'll share with you. Like I was appointed by NCLT, and this was a case Bank of Baroda versus the PG. So I approached the bank, and then when I was presenting my case in the court, so what happened is that they had already filed an application to replace the RP. Now, why? Because my name got selected by mistake, which court also admitted in the proceedings. The honorable judge mentioned that it's a mistake because there was a name which was already proposed in the application, section 95. And later we came to know that the person who was proposed as a RP, his application got rejected because his authorization for assignment was not valid, and they didn't have much time actually to go and check that. Maybe there was some kind of a communication gap, I'm not aware. Then I got appointed. And when I got appointed, and then when I was presenting my case after 10 days, when I was sharing the report in the court, so that time, the same application also came in front, that way they wanted to replace the RP. So the court ordered that first, this IRP, RP should get all his fees and expenses. And then we will replace the RP because he has done a lot of work. So eventually I got lucky and I started negotiating with the bank. So I got paid some amount over there. So my expenses were cleared and some nominal fees I received. So in that case, that is what happened with me. But otherwise, I think in this case, mostly it will be the cost, which as of now, I think it will be borne by the RP, or he can negotiate with the applicant. I hope that helps. And Nidhi, so interim moratorium and moratorium are two different stages. So what I was trying to say earlier is that one is when you apply for insolvency. So in this case, the debtor himself has applied for fresh start process. So he has filed an application. The moment you file an application, the interim moratorium starts, where all the legal proceedings will be on stay, which we will cover in detail. But once the application gets admitted by the adjudicating authority, then the moratorium starts. So basically, they have given an additional cushion in case of individuals that you will have a two-stage moratorium. Now, let's say in some cases, maybe the application might get rejected. So in that case, the interim moratorium will come to an end. I hope that helps. Nidhi ji, Vinay Kanji. Okay. So next stage would be the adjudicating authority either admits or rejects. So if it admits, then the moratorium will start. Then once the moratorium starts, there are some specific do's and don'ts for the debtor, right? Which we will see in the court. Basically, he cannot travel abroad outside India. He cannot take any directorship. He cannot get into any kind of a business as a partner, as an MD. Or if he does, there has to be a specific permission from the adjudicating authority, and he has to keep the RP also in the loop. So those are very important do's and don'ts. And also in the exam, you can get a question on these kind of things, right? Then once those do's and don'ts are covered, the creditor, then there are some other processes, whether if any creditor has an objection, could be the qualifying amount is not correct, or it was qualified, or maybe the amount was not included. Maybe the debtor or the creditor, they want to replace the RP, or if they want to revoke the application. So there could be many different situations. And then the last stage would be discharge order. So discharge order basically will be given by the educating authority. So this is how broadly the process works. Now we will look at the code. So before we go to the code, any questions? Okay. Just 1 minute. Okay, I hope my screen is visible. In case not, do let me know. So as I mentioned, now we are looking at part 3 of the code, right? Which is individual and partnership firms, insolvency and bankruptcy. And bankruptcy is equivalent to this one, liquidation. So the first chapter covers preliminary. I have covered few of the things already in advance, but I'll just quickly highlight a few of the important parts. Shall apply to matters relating to fresh start, insolvency, and bankruptcy of individuals and partnership firms, where the amount of default is not less than 1,000 rupees. Remember, not less than 1,000, right? Provided the central government may by notification specify the minimum amount of default of higher value, which should not be more than 1 lakh rupees. So in case of CRP, it is max is 1 crore, which is currently the limit. So in case of individual, it is 1,000 as of now, and max could be 1 lakh rupees. Now, in this part, educating authority, as I said, it's DRT, Debt Recovery Tribunal. So sometimes they might ask a question that DRT constituted under subsection 1(3) of what? They might give you 4 options. So it is Recovery of Debts Due to Banks and Financial Institutions Act, right? I think it's also called RDTB FI. So remember this. DRT is constituted under this specific act. Then associate. Now, because we're looking at the debtor, he would have many associates because he might be in a business, he might have his own company, or he might be under employment also. So in that case, they have given a specific definition for associate of a debtor. So first is immediate family, right? Second is a relative of the debtor or relative of the spouse. Sala and all that, or everybody, or maybe Sali, everybody is covered, in-laws. So all are covered as a relative of the spouse also. A person who's in partnership with the debtor. So in case if there's a business, if there's any partner, that also will be covered as an associate. Then spouse or relative of any person with whom the debtor is in partnership, which means the relative and spouse of the partner also. Employer of the debtor or employee of the debtor, and then trustee of a trust in which beneficiary of trust include a debtor. So first is the debtor should be the beneficiary, and the terms of trust confer a power on the trustee, which may exercise for the benefit of the debtor. So basically the underlying is that the person trustee of a trust will get included as associate if it is the trust is for the benefit of the debtor. Company where the debtor or the debtor along with his associates, so associate is already covered above, own more than 50% of the share capital, or they control the appointment of the board of directors of the company. So in this case also, that company will be included as an associate. Now for this purpose, relative with reference to any person means anyone who is related to another if they are members of HUF. One person is related to other in such manner as may be prescribed. So again, the definition of relative also has been clarified. Bankrupt. So bankrupt, as per specific to this code, it would basically means a debtor who has been adjudged as bankrupt by a bankruptcy order. So usually Adjudicating authority passes an order under section 126 and declares the debtor as a bankrupt. So once the debtor is declared as bankrupt, then only he will be falling under the definition of bankrupt. Now, in case if there is a partnership firm and there is a bankruptcy order under section 126, so all the partners of the firm will be termed as a bankrupt. So you can expect 1 mark MCQ on such question. So who all will be bankrupt if it is a partnership firm which has been declared as a bankrupt under section 126? Any person adjudged as an undischarged insolvent, right? Also, it will be a bankrupt. Bankruptcy means state of being bankrupt. Bankruptcy debt. Now, this is important. So bankruptcy debt is a debt owned by him, basically the debtor, as on bankruptcy commencement date. So this is very, very important. So the debt owned by him as on the bankruptcy commencement date. So the way we have insolvency commencement date, similarly bankruptcy commencement date, and the debt owned would be called as a bankruptcy debt. If only one partner, then does all partners are also covered? Yes, we will cover that in the definition. So your question, Prakashji, is that if one partner is bankrupt or one partner is insolvent? So, okay, if I understood your question correctly, eventually what will happen is, so bankrupt. See, here the point is that if it is an individual, then only that specific partner will be bankrupt. But let's say if there is a bankruptcy file against the partnership firm and under section 126, the entire partnership firm has been declared as bankrupt, all the partners will be declared bankrupt. That is how it is. Any interest. Now, bankruptcy debt also includes any interest which is part of the debt under section 171. So this we will discuss when we come there. So this includes interest also. Bankruptcy commencement date, date on which bankruptcy order is passed by adjudicating authority. Bankruptcy order passed by adjudicating authority under section 126. Bankruptcy process, process against the debtor for under chapter 4 and 5. Bankruptcy trustee. So I had 1 mark MCQ on this. Very simple and straightforward. Like, who is a bankruptcy trustee? They had given me option. So it basically means an insolvency professional appointed as a trustee for the state of the bankrupt under section 125. Chapter is okay. Committee of creditors means committee constituted, section 134. And then debtor. So debtor includes judgment debtor. Here I've just added the definition of judgment debtor. Judgment debtor basically means a party against which unsatisfied court decision is awarded, right? Or a person who is obligated to satisfy a court decision. So there is a decision by the court. There is some kind of action or some kind of a amount which is due by the person. Other way to look at it is a term judgment debtor describes a party against which court has made a monetary award, right? I hope it's clear. Gupta sir, you want to add anything on judgment debtor, or is it clear? Okay. Discharge order. So this is the order passed by adjudicating authority discharging the debtor under section 92, 119, 138. So there would be fresh start process, individual insolvency, or bankruptcy. So any order as an insolvency or maybe a bankruptcy, any order passed by adjudicating authority will be a discharge order. Now, excluded assets. This we actually already saw in the presentation. So I will not get into much details, but always remember that these are the assets which are owned by the debtor, number one. Second, they should be unencumbered. Third, they should be for personal use, right? Which could be for employment, business, or vocation. And in terms of the amount, so only the amount so far which has been declared is for personal ornaments, which I said 1 lakh rupees, right? And very important that they should be part of the religious usage. That is important. Second, dwelling. So in case of dwelling also, It should be unencumbered, single dwelling, right? Only one house, which should be owned by the debtor. This is very important. And the value is 10 and 20, 10 for rural and 20 for urban, 10 lakhs and 20 lakhs. And as Gupta sir clarified, it's a market value. Excluded also we saw fine imposed, any damages for negligence, nuisance, or breach of statutory contractual obligation, maintenance in case of like divorce as an example, student loan. So this we discussed. Now in case of firm, partnership firm, this basically means a body of individuals carrying on business in partnership, whether or not registered. So if you remember the presentation, I clarified that partnership firm will include both, either it is registered or not registered. Now see this immediate family, when we are looking at associates, relative, so they have defined what is immediate family also here, which will include spouse, dependent children, and dependent parents. Partnership debt means debt for which all the partners in a firm are jointly liable. If there is any partner which has an individual liability to a particular debt, that will not be counted as a partnership debt. Qualifying debt, I think we discussed this in a presentation, so I'll not spend much time. So this basically includes your excluded debt, which we saw above, and debt to the extent it is secured. So the example about how the home loan I gave you, 70 lakhs and 50 lakhs. So the only part which is unsecured will be included in qualifying debt, right? And debt which has been incurred 3 months prior to the date of fresh start process. Repayment plan. So this is very similar to resolution plan, right? This means a plan prepared by the debtor. So see, this is always remember the repayment plan is always prepared by the debtor. So the debtor will decide how he wants to pay in terms of timeline, the amount, and to whom, because he might have multiple creditors. So it will be prepared by the debtor, but yes, it will be in consultation with the resolution professional. And this would be under section 105, containing a proposal of committee of creditors for restructuring of his debt. So usually it happens that when he prepares a repayment plan, there will be a COC in this case, and then they will discuss. Maybe there will be some kind of a restructuring. So maybe to one debtor, he might, for example, he might own 5 lakhs, and maybe mutually they might agree, okay, let's reduce that 5 lakhs to 3 lakhs. So in these kind of situations, if it is discussed, the repayment plan will be prepared accordingly. Sir, any debt meaning qualifying debt? Yes, any debt means qualifying debt, because the qualifying debt is the only debt which will be for which the debtor will be discharged. Other than that, nothing will be, he will be discharged from. Resolution professional. So I think we know that this is the insolvency professional appointed as a part of resolution professional for conducting the fresh start process or the insolvency resolution process. So now if you see here, it is the RP appointed for either the fresh start process or the insolvency resolution process. Now, can anyone tell me why they are not including bankruptcy over here? Why resolution professional does not include bankruptcy? Arundhati ji is asking, are valuers professionals engaged or is it totally handled by the RP? Arundhati ji, I'm not sure if I follow your question completely, but valuers are professionals which are appointed by the resolution professional. Sorry, I'm not able to follow your question completely. Maybe you can add something else also. Can anyone tell me why it's not including the bankruptcy? So I just covered on the top, and this is very important. So this would be also asked in the exam. It's a bankruptcy trustee. So whenever a resolution professional is appointed to manage or to handle the bankruptcy case, his designation for the sake of discussion will be bankruptcy trustee and not resolution professional. So please remember this. So values professional engaged is totally handled. See, I think in this case, I don't see any situation where they will be appointing a valuer. It will be the decision of the RP or the bankruptcy estate. But if required, he can appoint. Now, before appointing, also he has to ensure that what would be the cost involved. And if there is a COC, so he has to take their permission also. Something similar to what we saw in CRP. Liquidation part will be appointed. Yeah, that's correct, Bansalji. But the point was what it is called. So in other cases, it is called RP, but it's for bankruptcy, it's called bankruptcy trustee. That was the point. Because 1 mark MCQ could be asked for that specific point. Undischarged bankrupt who has not received a discharge order. Okay. So fresh start process. Now we'll look into more detail. Any questions on so far? No, right? Or you can just put it on the chat, which is fine. So fresh start process, eligibility for making an application. Now, very important part here, which I mentioned in the presentation also, that it is only the debtor himself he can apply for fresh start process. So a debtor who is unable to pay his debt and fulfills the condition specified in subsection 2 shall be entitled to make an application for fresh start for discharge of his qualifying debt, right? Discharge of qualifying debt. So Bansalji or somebody asked me, right? The discharge will always be only for the qualifying debt. A debtor may apply either personally or through an RP for a fresh start under this chapter in respect of qualifying debts to the adjudicating authority. Now, what is the eligibility? The gross annual income should not exceed 60,000. So I remember I had 1 mark MCQ, a case study on this also in one of my attempts. So they had given different details, and basically I had to confirm whether the debtor is eligible for the fresh start process or not. So this is very important. Gross income should be not more than 60,000. Aggregate value of assets of debtor, which means the assets which he is owning or she is owning, should not be more than 20K. And aggregate value of qualifying debts, which means the whatever debts for which he is requesting for a fresh start process should not be more than 35,000. I mean, these amounts are very negligible in today's scenario, but still, I think they might revise the amount once it gets notified. And he's not an undischarged bankrupt, and he does not own a dwelling unit, irrespective whether it's encumbered or not. Obviously, because with this amount, with this income, it's doubtful whether he will own a dwelling. And the fresh start process, insolvency or bankruptcy is not subsisting. Basically, it is not in force. And no previous fresh start process was completed 12 months preceding the date of application. So if these conditions are satisfied, then he can go for a fresh start process. Now, how to apply, right? So when an application is filed under section 80 by the debtor, interim moratorium shall commence on the date of filing. So as I mentioned, there are 2 moratoriums, interim and moratorium. Interim will commence on the date of filing of the application in relation to all the debts and shall cease to have effect on the date of admission or rejection. So one thing which my understanding or my interpretation is that this is for all the debts. It is not for qualifying debts. Gupta sir, if you have any view on this, please share. Like whether the interim moratorium is for all the debts or only for qualifying debts. Or maybe Sunil sir, if you have any views on this.
Prakash ji, whatever is written, we'll go by that only.
Correct. Okay. So the interim moratorium starts in relation of all the debts and cease to have effect on the date of admission or rejection. Now, during the interim moratorium, what exactly happens? So basically, any legal action or legal proceeding pending in respect of any of his debts shall be deemed to be stayed. Obviously, which means whatever current legal proceedings are going on, they will be by default be stayed. And there is no fresh legal action or proceeding which any creditor can initiate against the debtor. So Gokulji, there are specific do's and don'ts. Those are specific to when the debtor actually, it's accepted once the order is admitted. So in case of interim moratorium, I think the debtor can travel outside the country. But in this situation, it would be a little complicated because if you see here, once the eligibility is so less, his gross total income is less than 60,000. I don't think he will have money to travel outside, number one. Second is that he himself is applying for insolvency. And if he travels abroad, I don't think that will make sense. But as per the law, there is no specific condition saying that he cannot. Once it is admitted, then it's very clear that or with permission he can. The application under Section 80 shall be in such form and manner accompanied by such fees. So I'm not very clear about the fresh start process because it is not being notified yet. But for a PG, the fees is around 2,000 rupees. So if the PG himself wants to initiate the application, I think that is Section 94, that will be 2,000. Even if the creditor initiates the insolvency proceeding against the PG, the fees is 2,000 rupees. The application under subsection 3 shall contain the following information supported by an affidavit. So from a practical experience, I'll tell you one thing, that whatever application you are going to submit, so that would be along with an affidavit, number one. Second, recently, I think 3 months back, any specific application report, status update, which you have to give to the to the NCLT, Educating Authority, one, that will be filed as an IA, which is interlocutory application, and second, it is always notarized, right? So recently, when I was going through all these proceedings for the personal guarantors, whatever I've submitted, everything was notarized and it was along with the affidavit, and it was filed as an IA. So if there is a report which you have to file under Section 95 or 99, that is fine. But other than that, if there's any status update, it is always interlocutory application. So the application will contain following information: list of all debts owned by the debtor as on the date of said application, along with the details of amount of each debt, interest payable thereon, and the names of the creditors to whom each debt is owed. Basically, the entire list of debts along with the interest and the name of the creditors. Next, interest payable on the debts and the rate thereof stipulated in the contract. So obviously there would be a contract between the debtor and the creditor. So he has to provide the interest along with the rate. Then the third would be list of securities held. So home loan example, whatever any security has been held by the creditor, that also should be included in this application. Financial information of the debtor and his immediate family up to 2 years prior to the date of application. If you recollect the process flow, I had mentioned that the decision to admit or reject will always be supported by the report of the RP, correct? Now, if RP has a responsibility to give a report to the educating authority whether they should accept or reject, he should have some information about the debtor, right? In some cases, even if he's not appointed or proposed, or maybe he's appointed by the court, in that case, how exactly he will do it. So this application copy is very, very important. And this particular information about financial information. So if you go to the rules and regulation, they have specifically mentioned what exactly would be financial information. So that also has been clarified. And this important point to note here is it includes the immediate family. And immediate family also has been defined, right? Which is your children, spouse, and dependent children and dependent parents. So all the financial information about the family and the debtor up to 2 years prior to the date of application should be part of the application. Debtor's personal details as may be prescribed, physically name, address, and all those things. The reasons for making the application. So this is where the debtor will justify that why he is not able to pay. Then particulars of any legal proceedings which to the debtor's knowledge have been comments against him. So if you see, the interim moratorium will begin after the application is filed. But maybe before that, if there is any legal proceedings, like for example, in case of a home loan, maybe the bank might have filed some case against the debtor. So he has to provide those details also. Confirmation that no previous fresh start order under this chapter has been made in respect of the qualifying debts in the preceding 12 months of the date of application. This is an important condition. If this is the case, obviously the debtor will not be eligible for the fresh start process. So he has to confirm that there was no fresh start process preceding 12 months of the date of application. Now comes the resolution professional. So this is the appointment of RP. So two situations, either the debtor has applied along with the proposed RP, or maybe he has not applied along with the proposed RP. He has not proposed any RP basically. So where an application filed by the debtor through an RP, the adjudicating authority shall direct the board within 7 days. So these days are also very important. Now, I think in CRP, it is 14 days. In case of individual, it is 7 days. So it would be very handy, and maybe Gupta sir might have already given that information or might be available, that for each and every situation.
Yes, sir, we have already shared the chart. We have already shared the chart.
Great. Great. So the number of days is very, very important, because in the case study, they will ask you these questions also. So the adjudicating authority shall direct the board within 7 days of the date of receipt of the application and shall seek confirmation from the board that there are no disciplinary proceedings against the RP, right? So this is a standard process where always the adjudicating authority takes a confirmation from the board. But please remember, the appointing authority is always adjudicating authority. The board is never an appointing authority. So you might get a question in the exam that it was appointed by the debtor, the creditor, the board, or adjudicating authority. Appointing authority is always adjudicating authority. The board shall communicate to adjudicating authority in writing the confirmation of the appointment, right? Who was part of the application or rejection. And if they are rejecting, they have to nominate another resolution professional suitable for the fresh start process. Now, this nomination basically happens. So practically, I'll tell you one thing. So nowadays, board doesn't nominate. It was a couple of years back when the board nominates. Now, what happens is the board already has an impaneled list of IPs, which is published. So that is already there with the NCLT. And it is by the specific bench. So for example, I'm impaneled with NCLT Mumbai, correct? Now they already have a list. So that list is confirmed by the board. So if there's any change in the list, the board always give that confirmation to the adjudicating authority. So basically NCLT will just pick the name from the list of the impaneled RPs. Where an application under Section 80 filed by the debtor himself and not through the RP, the adjudicating authority shall direct the board within the 7 days of the receipt. So again, the same thing, they will actually use an impaneled list of RPs and pick one of them. There would be a confirmation from the board if required, but otherwise it will be based on the impaneled RPs. So the process says that the board within 7 days of the receipt has to, of the application, nominate a RP for the fresh start process, and board shall nominate RP within 10 days of receiving the direction. The adjudicating authority shall by order appoint the RP recommended or nominated by the board. So again, I'm re-emphasizing this point because this is very important. The appointing authority is always adjudicating authority. So unless, like in case of authorized representative also, which we discussed a couple of weeks back, right now I am just part of the announcement, but I'm not being appointed. And the IRP is going to just propose the name of the person who has the maximum votes. That proposal by IRP doesn't mean appointment unless it is in the court order that the authorized representative or the RP has been appointed. Resolution professional appointed by adjudicating authority under subsection 1 shall be provided a copy of application for fresh start process. Now, this is very interesting. So I'll share a practical perspective here. In my case, when I was appointed as an IRP for a BG case, so the order came on 5th of July, and till 1st of August, I was not aware about it. So ideally, the application was filed by Bank of Baroda. And the moment order came on 5th of July, Bank of Baroda was expected to reach out to me to convey that you have been appointed as a RP. But eventually, due to some other reasons, they couldn't, or they tried, I was not reachable, maybe because the phone number is not there on the IBPI website and so on. They might have valid reasons. So I was not communicated. Now, this is one. Second, as per the process, NCLT, if you remember the mail which I showed you in the beginning, 6th of August. So there is a mail which NCLT sends to the RP also or IRP that you have been appointed. So this communication is very, very important because the moment you get communicated, the work would start, right? In case of 10 days, or maybe if there is a public announcement, or you have to start requesting for claims. So this date is very important. Now, if there is a situation where the educating authority has by mistake not communicated to the RP, or the creator has not communicated to the RP, so whenever the RP comes in the knowledge of that particular on date, like in my case, I came to know about 1st of August, and it was eventual. My associate was in the NCLT. So through some personal conversation, they came to that I'm appointed. Then they went on the website, they downloaded the order, and then I came to know. So that is how. So in this case, it is always the NCLT who should inform the RP, or it could be the debtor also who should be informed. Now comes the next stage where the examination of application by the RP, right? So this is very important, and this is a responsibility of the RP that he has to give a report whether the educating authority should accept or reject. So the RP shall examine the application made under Section 80 within 10 days of his appointment. So I'll just share another perspective. In my case, when I was looking at the personal guarantor's case, the personal guarantor was in jail, right? He was in Arthur Road jail. So I reached out to the jail authorities also. I got a mail from that I have to seek a approval from the district court. And even if I seek the approval from the district court, if I get an appointment with the personal guarantor in the jail, the maximum time I'll get is 1 or 2 minutes. So eventually 1 or 2 minutes is too short a time to discuss. In fact, 1 or 2 minutes only goes in introducing yourself. And the Arthur Road jail, when I was talking to some of the advocates, it was a very like something which they have shown in the movies also. You get the place is very cramped. There are a lot of people who want to meet and so on. So we are looking at alternatives. So within 10 days, it is very difficult to actually get a confirmation from the personal guarantor. So what I did is that basis whatever information I could gather using emails or maybe sending postal letters to the to the debtor. So I created a status report, because within 10 days, it is very important that you have to give an update. So even if it is going to get delayed or whatever, you should always ensure to the timeline. So within 10 days, if you're not able to give the a report that whether it should be admitted or rejected, at least you can update the educating authority. So in this case, within 10 days, the RP will submit a report to educating authority recommending acceptance or rejection. Now, this recommendation will be basis what? So first is a report referred to in subsection 1 shall contain the details of the amount mentioned in the application, which in the opinion of RP are qualifying debts. Right? So in case of fresh start process, it is max 35,000. Liabilities eligible for discharge. Obviously, that would be part of the qualifying debt. RP may call for such further information or explanation in connection with the application as may be required from the debtor or any other person in the opinion of RP. So this is very important. And this is where the delay happens. So going back or repeating myself, you should submit a report within 10 days and you should update the educating authority that there is some information pending, and that is what we have called for. Everything has to be documented. So emails, whatever application you report you filed with the educating authority, you have to prove each and every document. A debtor or any other person, as the case may be, shall furnish such information within 7 days of the receipt of the request. Now, in my case, the debtor was actually in the jail, so it was not possible. Resolution professional shall presume that the debtor is unable to pay his debts as on the date of application. So if you see, the code says that it is an assumption, it's a presumption that the debtor will not be able to pay the debts, right? If, and that's a very important point here, if in his opinion, the information supplied in the application indicates that the debtor is unable to pay his debts and he has no reason to believe that the information supplied is incorrect. So this, in a way, onus is on the RP. Second, he has reason to believe that there is no change in the financial circumstances of the debtor since the date of application. Correct. So this reason to believe also has to be justified. On what basis? The RP shall reject the application if, in his opinion, the debtor does not satisfy the condition. Basically, the condition for fresh start process, they could be the annual gross income is more than 60,000, the qualifying debt is more than 35,000, so on. So that is a very important condition. Basic criteria is not satisfied, so he will say reject the application. The debts disclosed in the application by the debtor are not qualifying debts. So we discuss what is the definition of qualifying debts. If it doesn't fit in the definition, the application will be rejected. Debtor has deliberately made a false representation or omission. Basically, the debtor is trying to escape the liability. So that is why he has made a false representation. The RP shall record the reasons. Now, this is very important for recommending the acceptance or rejection. So everything what you do, you have to justify, record the reason of the application, the report to the adjudicating authority under subsection 1, and shall give a copy of the report to the debtor also. So if I have to quote my personal case, when I actually filed the report with the adjudicating authority, I actually emailed the debtor, right? Now the debtor was not reachable. So I tried to find out the lawyer, the debtor's lawyer. So I emailed a copy to the lawyer also, and I emailed a copy to the creditor also in my case. So this is the responsibility of the RP, that he has to keep all the concerned people, communicate and keep all the concerned people up to date about the status. Admission or rejection of application. So adjudicating authority may within 14 days from the date of submission pass an order either admitting or rejecting. Now, obviously, adjudicating authority will pass an order based on the recommendation of the RP report. The order passed, so accepting the application shall state the amount which has been accepted as qualifying debt. Possible that the RP might have given a different amount, but the adjudicating authority has the right to choose a different amount. All conditions of section 82 to comply for fresh start, that is income if 70K in previous year, will he be eligible for fresh start process? Thank you. Section 82, yes. So Gokulji, whatever conditions are said in terms of gross income, in terms of qualifying debts, or he should not have a dwelling, all those conditions should be satisfied. Then only if it is in that case, the fresh start process will be admitted. Income of 70K. So it is gross income of 60,000, not 70,000. Yeah, it is previous year. Basically, they will look at the annual income. So if it's, let's say, for example, he's applying on 29th of September. So they will look at the annually, what is his income, right? Okay. The order passed for current year, yes. So see, in this case, annual income current year, if I look at April to April to March 22-23, you obviously not have visibility. So maybe in this case, if you remember, the application includes financial information for last 2 years. Correct? That is one of the conditions when you apply for fresh start process. So that also will give you an idea that whether his annual income is around 60,000 or not. So that also can be considered. Order pass accepting the application shall state the amount which has been qualifying amount, right? So as I mentioned that maybe the amount which the debtor has put could be different, RP has approved could be different, and the amount as per the order by adjudicating authority could be different, right? And other amounts eligible for discharge under section 92 for the purpose of fresh start. So 92 is basically your insolvency for the individual. Copy of the order passed by adjudicating authority along with a copy of the application shall be provided to the creditors. Now, usually the order is passed by the adjudicating authority, right? Basis the application from the debtor and basis the report from the RP. Now it says that the copy of the order and copy of the application shall be provided to the creditors mentioned in the application within 7 days. So they haven't mentioned who is going to provide the copy, but as per the reading, as per the interpretation, you can interpret that it should be the adjudicating authority, but usually it is the RP who actually provides the copy to all these concerned people once he gets the order from the adjudicating authority. Now, effect of admission application. So this is where the moratorium comes into play. So we discussed interim moratorium. Now, let's say if the application is admitted, the interim moratorium ceases to continue, and then the moratorium will start. And if it is rejected, obviously the interim moratorium also ceases. So on the date of admission of the application, moratorium period shall commence in respect of all the debts. During this period, pending legal action or legal proceeding in respect of any debt shall have been deemed to be stayed, same thing. Subject to the provision of section 86, the creditor shall not initiate any legal action against the debtor or proceedings in case of any debt. Now, during the moratorium period, so I think Bansalji was asking, or Prakashji, somebody asked that what are the do's and don'ts. So if you see here, it's very specifically mentioned that during moratorium period, the debtor shall not act as a director of the company, directly or indirectly take part in the concern in the promotion, formation, or management of the company. So basically, he is restricted, right? Now, the moment he becomes a director or he is part of the promotion formation, so it is contradictory. On one side, he is filing an application for Fresh Start process. On the other side, he is promoting a company. So that shows that there is some kind of a disconnect, right? So that is why he cannot do this. He cannot dispose or alienate any of its assets. Obviously, once the case is admitted, all the assets will automatically be controlled by the RP. So in this case, the debtor will not have any control on this. So he cannot basically sell or say that, okay, I have gifted this to my relative and so on. He cannot do anything of that sort. Inform his business partners that he is undergoing a Fresh Start process. So if it is a partnership firm, he has to inform this to the business partner. So this is the responsibility of the debtor. Be required to inform prior to entering into financial or commercial transaction. So in case if he's entering any financial or commercial transaction, he has to inform the party with whom he is entering into such transaction. Disclose the name under which he enters into business transactions if it is different from the name. So obviously, same thing if he is getting into any specific business transaction with a different name, maybe to escape. So instead of ABC partnership or maybe ABC Private Limited, now he's part of XYZ Private Limited. So those kind of change in names. So he should be disclosing all that in case of any business transaction. Not travel outside India except with the permission of adjudicating authority. So please note, you might get a 1-mark MCQ that whose permission would the debtor need? It is adjudicating authority, not the insolvency professional or the creditor or the board. It is adjudicating authority. The moratorium ceases to have effect at the end of the period of 180 days beginning from the date of admission. So the point here to note is that the period of Fresh Start process is 180 days, and it starts from when the application is admitted, not when the application is filed, and it ceases when after 180 days, right? Unless the order admitted the application is revoked. Objections by creditor and their examination by RP. So any creditor mentioned in the order of the adjudicating authority under section 84 to whom a qualifying debt is owed may within a period of 10 days from the date of the receipt of the order. So the receipt of the order is basically when the application is admitted. And if you remember, we discussed that the order should be communicated to the creditor also. Once he receives the order, within 10 days, he can file an objection. And this objection should be on the following grounds. Inclusion of a debt as a qualifying debt, right? I don't know why they says inclusion of a debt as a qualifying debt. Maybe could be some arrangement between the debtor and the creditor, or incorrectness of the details of the qualifying debt. Maybe the amount is less, or maybe something is missing in the qualifying debt. So in this case, he can file an objection. Now, please note that the objection should be by way of an application to the resolution professional. So again, 1 mark MCQ in the exam, that if a creditor has to file an objection, whom will he file? Will it be with the board? Will he be with the educating authority? Will he be with the debtor or the resolution professional? So the answer is resolution professional. This is also very important. See, this is how they will frame 1 mark MCQs and ask you. The application shall be supported by such information documents as may be prescribed. The resolution professional shall consider every objection made under this section. So he has to prove that he has reviewed, considered every objection. He can't ignore that objection. The RP shall examine the objections and either accept or reject within 10 days of the date of application. Okay. So within the date of application, he has to accept or reject. The RP may examine any matter that appears to him to be relevant to making the final list of qualifying debt for the purpose of section 92. Now, in this case, earlier, the RP proposed to admit the application. Application has been admitted. Now, the debtor has objected for certain things. So now the RP can, basis these objections, revisit the qualifying debts also. Correct? So maybe he will increase or decrease depending on how valid the objection is. So just one second. Yeah. And on the basis of the examination, the RP shall prepare an amended list of qualifying debts, obviously once he reviews each and every objection, for the purpose of discharge. Make an application to educating authority for direction under section 90. Basically, if he has to, if he is not very sure what exactly he needs to do, or maybe he is not able to take a decision, right? And he needs some kind of a direction. So RP can always reach out to the educating authority in such cases. Take such steps as he considers necessary in relation to debtor. Application against decision of the RP. Now, there is a situation where there is no objection, but RP doesn't accept that decision, right? That could be by the debtor or the creditor. So here, both the debtor and the creditor have the right to actually approach the educating authority against the RP, right? So debtor or creditor who is agreed by the action taken by the RP under section 86, within 10 days of such decision, make application to educating authority challenging such action, namely where the RP has not given opportunity to the debtor or creditor to make a representation. So basically, like a natural justice. So he should always give them opportunity to share their view, or if they have any objections or any concern. That opportunity is very important to be given by the RP. Second, RP colluded with other party in arriving at a decision. So in practical scenarios, sometimes it happens that there are multiple creditors and RP joins hands with some creditor. So in such situations, the debtor or the creditor can file an objections with the educating authority. RP has not complied with the requirements of section 86, as we saw, basically the eligibility. Educating authority shall decide in subsection 1 within 14 days of such application and make an order. Where the application of subsection 1 has been allowed by educating authority, shall forward this to the board. Now see, there is an objection which has been raised by the debtor or the creditor against the RP, right? Now, the educating authority has actually within 14 days taken a decision and they have passed an order. So this order should also be shared with the board, which is IBBI, right? And board may take such action as may be required against that. General duties of the debtor. Now, this is the debtor, right? He has to make available to the RP all the information relating to affairs, meetings, comply with request of RP in relation to fresh start process, inform the RP as soon as possible of any material error or omission in relation to information documents supplied. So if there was any omission, he has to inform the RP ASAP. Or if there's any change in the financial circumstances, maybe he won a lottery, right? Now he has money, so he can at least inform the RP that there is a change in the financial circumstances. So maybe he is able to pay the debt. Replacement of RP. So debtor or the creditor is of the opinion that the RP appointed in section 82 could be required to be replaced. They can apply to executing authority for the replacement of such RP. Now, the same process, 7 days, 10 days, board, disciplinary cases. So that same process will apply over here also. So I'll not get into details. I think this is very straightforward. And then comes section 19, directions for compliances of restrictions, right? So usually, if you remember, we discussed, I think it was section 86 or 87, where the debtor has to comply with certain restrictions. He cannot travel abroad. He has to inform his partners. If he's getting into any kind of a financial or a business association, so he has to declare that. He has to inform the RP also. So let's say if there is a situation where the debtor is not complying to those restrictions. So what will happen? So RP may apply to executing authority for any of the following directions. So if you recollect section 19 subsection 2, right, where there is no cooperation by the corporate debtor. So in that case also, there is an application which an IRP and RP can file with the NCLT, right? There is no non-cooperation from the CD. Section 19 subsection 2. Exactly same situation in this case also, where the RP can file an application with executing authority if the restrictions are not being followed. So namely, compliance of any restrictions reference subsection 385 in case of non-compliance by the debtor, or the compliance of the duties of the debtor, where he has to inform the RP if there is any change in financial circumstances or if he has omitted any information. So that is also, that's a duty of the debtor. So if that has not happened, RP can approach the executing authority. RP may apply to executing authority for directions in relation to any other matter under this chapter, obviously. So that is the go-to authority for him. Revocation. So revocation of the order admitting application, the RP may submit an application to executing authority seeking revocation. So this is similar to section 12A in case of CRP, all right? Section 91 talks about the fresh start process where the order can be revoked. Now, on what grounds? So there was one question which came to my mind, which I thought I'll ask all of you. Can a revocation be initiated by the debtor himself for a fresh start process? Anybody? Or maybe Gupta sir, Sunil sir, if you want to add anything. Revocation of a fresh start process by debtor. Okay, so the answer is no, right? Because right now, as per fresh start process concern, if there has to be a revocation, it has to go through the RP, right? And RP has to provide a report to the executing authority that why it should be revoked. So if you see here, the grounds are due to any change in the financial circumstances of the debtor is ineligible for the fresh start process, or non-compliance by the debtor, like imposed under section 85. There is no provision in the code, absolutely right, Prakashi. So the debtor cannot do that. He cannot revoke. It has to be through RP. If debtor has acted in a malified manner or has willfully failed to comply with the provisions, the executing authority within 14 days receipt of the application may by order admit or reject the application. On passing the order admitting the application, the moratorium and the fresh start process will cease to have effect, and copy of the order passed by the executing authority shall be put to the board for the purpose of recording an entry in the register referent to section 196. So we'll look at this section later, but basically all the final orders of executing authority under section 196 are supposed to be provided to the board. Now, the final stage, discharge order. So whatever qualifying debt, let's say the application was admitted, RP recommended to admit the application, educating authority admitted the application. So finally, now educating authority is of the view that, okay, so these are the debts which are qualifying. It fits all the requirements as per IBC, and they can actually pass a discharge order. Discharge order basically would mean that now the debtor, which is part of the fresh start process, he need not pay this amount to the creditor. That would be the discharge order. So what it says, RP shall prepare a final list of qualifying debts and submit such list to the adjudicating authority at least 7 days before the moratorium periods to an end comes to an end. So anybody, what was the time period for moratorium to come to an end? Anybody wants to answer that? How many days? Absolutely right, Bansalji. Alokji, absolutely right. 180 days. So which means 7 days before the commencement, before the moratorium period ends, which is on before 173 days, the RP has to file this list with the adjudicating authority. The authority shall pass a discharge order at the end of the moratorium period for discharge of the debtor from the qualifying debts mentioned in the list under subsection 1. Without prejudice to the provisions, the authority shall discharge the debtor from the following liabilities mainly. Now, there could be, in the case study, they might ask you this question, that if the discharge order is passed, it would be passed for which liabilities? So penalties in respect of qualifying debts. Now, eventually what happens is, if you see, if there was a home loan, and right now, let's say the home loan was only for example, because qualifying debt is 35,000 should be less. Let's say, for example, it was only 25,000. But there could be a situation where there would be certain penalty the bank would have imposed, or maybe certain interest they would have included as a penal interest. So if the authority discharges the debtor, so whatever penalty or interest on that qualifying debt, that also would be part of the discharge order. So the debtor need not pay the penalty or the interest. So penalty in respect of the qualifying debts from the date of application till the date of discharge order. Interest included, including penal interest in respect of qualifying debts. So a very important point here is that in respect of qualifying debts, this is number 1. Second, the time period till the discharge order, right? And if it is interest, from the date of application till the date of discharge order. If there is anything before that, that will not be part of the discharge order. They will not relieve the debtor from that particular. So please remember this dates is very important. It is only for that particular dates. Any other sum owed under any contract in respect of qualifying debts from the date of application till the date of discharge order. Now this is important. The discharge order shall not discharge the debtor from any debt not included in the subsection 2 from any liability not included under subsection 3. Basically, anything which is not part of the discharge order, obviously it is not a qualifying debt, right? Or maybe in terms of penalty interest for that particular period. So the debtor is not discharged for that amount. Please remember that, which means the debtor continues to owe that amount to the creditor. So only as per the order, whatever amount is mentioned, that he would be discharged with. The discharge order shall be forwarded to the board for the purpose of recording. So 196, any order by adjudicating authority will go to the board also. A discharge order subsection 1 shall not discharge any other person from any liability in respect of the qualifying debts. So basically it says right now they are discharging the debtor, but that doesn't mean if that amount was jointly owned by some other person also, right? He also gets discharged. So it is that debtor which is getting discharged, not that amount which is getting discharged. So that is how it is so far. So we come to an end for chapter 2. Somebody's at the door. I just need 1 minute, please. Just give me 1 minute. So Gupta sir, maybe you can continue. I just need 1 minute. Please excuse me.
Okay, sir. Okay, sir. So participants, it is already more than 8:30. We are still in office, and I think this is the time to say thanks. But let Prakash Kurejaji come, then we'll thank him and wind up the meeting. Just let him join. Please be with us. So this is the time to say thanks to Prakash
Sure.
Kurejaji. It was really a wonderful session, and we enjoyed every bit of it. So we'll be looking forward to more such sessions. Thank you, sir. So
Sure.
we are ending
Thank you,
the
sir.
meeting with your permission.
Sure. Thanks,
Thank you, sir.
everyone. Thank you.
Okay, sir.